Testing. Testing. You got Commissioner, can you hear us?
Can you hear me?
Yes, we're all good now.
Perfect. Good morning. Welcome to the Commission's administrative meeting for May 3rd, 2023. Have a few opening statements. First, I'd like to recognize and welcome Ruthie Herman to the staff of the PSC Staff Council. Ms. Herman, are you here? There she is in the back row there. Good morning. Ruthie has come to us from the Comptroller's Office, where she served as a hearing officer for several years. She is a local graduate of UB Law School up the road by Penn Station, where she received the Royal Shannon House Honor. I don't know what that is, but it sounds very, very impressive. She also graduated summa cum laude from Wellesley College, where she majored in French and pursued an extensive coursework in art history. She is filling out the remaining vacancies in our Office of Staff Counsel on technical staff, and we welcome Ruthie to the team. Thank you. We have a few other issues. One is our PSE annual report was actually just submitted this week on May 1st. I would commend that document to your attention. It is a wonderful summary of all of the good work that the staff of the Commission has performed in calendar year 2002. It's upwards of 200 pages, hits all of our seminal orders and actions that we took over the course of the past 12 months. So take a look at the annual report that was just issued. Additionally, last week we issued our most recent quarterly report for supplier complaints. That was on for the months of January, February, and March. And I'd just like to point out a few of the highlights of that report. On the screen, and probably streaming live as well, we see our most recent quarter there in purple on the right side. You can see that we hit a record high number of complaints. In fact, it was 234 complaints in that first quarter alone of this year. In that little box, bottom center, you'll see that more than half of those complaints were for slamming or misrepresentation by the vendor to a potential customer. We track all suppliers with complaints of 3 or more in a given month. And taking a look at the quarterly results, you could see the suppliers with the most complaints in the bottom left. Constellation, a Baltimore-based company, with 39, Sunsea Energy with 23, and Indra Energy, which we've seen time and time again, with 17. It is disappointing to see such high levels of complaints. The Commission last month in April took swift action with respect to Sunsea, suspended its license, returned all of its customers to default SOS service, and has delegated this matter to the Public Utility Law Judge Division to determine whether additional penalties are necessary. You are well aware that we are in a maximum enforcement phase of 6 months. This is effectively a blitz. Additional staff have been supplementing the staff of the Compliance and Enforcement Unit, as well as the Consumer Affairs Division and the Office of Staff Counsel, in investigating and prosecuting retail suppliers that have no respect or are in violation of the Commission's regulations and state law. On this next slide here is the Hall of Shame, effectively. Suppliers with 3 or more complaints for the first 3 months, January, February, and March. Constellation New Energy is in the pole position, the unfortunate position of having the highest number of complaints in each of those months, followed closely by Sunsea, which is effectively now not doing any business in the state. You'll see SFE Energy there. The Commission took action against that retail supplier back in February, so I don't expect to see many more SFE complaints. Last week or the week before last, Staff Counsel revealed the identities of, I believe, 7 retail suppliers who they previously had issued a cease and desist letter to, informing them that they could not market in the state of Maryland. They released their hold on the cease and desist action. But let me be clear, there are other suppliers that were not mentioned on that letter that are currently subject to a cease and desist. And some of them are on this list before you today. Maximum enforcement phase will continue until August the 1st. That doesn't mean that after August 1st the Commission's going to get soft on this, but the sustained enforcement and aggregation of additional staff members warranted these actions, and there will be more to come. Thank you. We do have meeting minutes to approve from our last meeting 3 weeks ago, April 12, 2023. All in favor, please say aye.
Aye.
The meeting minutes are approved. Good morning, Mr. Secretary. Madam Secretary, force of habit.
Good morning, Mr. Chairman. There are 5 items on the consent agenda today. Items 1 and 2 are from NLX Advisory Services USA LLC. They're applications for both licenses to supply electricity or electric broker services and natural gas or natural gas broker services in Maryland. Item 3 is from Lexus Power LLC. Its request to cancel its electric broker license. Item number 4 is from Best Practice Energy LLC. Its request to cancel its licenses to supply gas and electric services. And item number 5 is from Texas Energy Options, Inc. Its request to cancel its broker license to supply electricity or electric generation services in Maryland.
Thank you. Seeing no questions from the commissioners, I would move that with respect to item number 1 and 2, that we grant the company a license to operate as an electricity supplier in Maryland with respect to item number 1, as a natural gas supplier with respect to item number 2, limited to broker services for the customer classes and service territories applied for and recommended by staff, that we direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in its respective applications. With respect to item number 3, 4, and 5, I move that we approve the cancellation requests. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motions are approved. Madam Secretary, the administrative agenda.
Thank you, Mr. Chairman. There's several items on today's administrative agenda. We will be making one slight change. We will be moving item number 15, Elkton Gas Company, its Stride 2022 annual report and reconciliation factor, up to the next item.
Thank you. Good morning, Ms. Garofalo.
Good morning, Mr. Chairman, Commissioners. Annette Garofalo on behalf of Commission staff. With me today are Mr. Adesina Iole of the Engineering Division, Mr. Mark Riley of the Accounting Investigations Division, and Mr. Evan Thomas of the Gas, Water, and Telecommunications Division. I have two changes to make to our comments. First, with regard to the recommendation, I would ask that we delete the following: table number 4, and then there's some more wording, a closed paren. This would have the recommendation read: staff recommends that the Commission direct the company to revise its tariff and bill the Stride surcharge revisions proposed by staff in Table 5 with an effective date of May 3rd, 2003, and the recommendation is found on pages 1 and 8. Second, with regard to the applicable law, the last paragraph, the applicable law is found on page 2. The last sentence, the word first should be replaced with second, and all words after reconciliation should be deleted. This would have the sentence reading: this is EG's second reconciliation.
Thank you.
So the Commission approved Elkton's first Stride plan by order number 89931, issued August 20th, 2021, directing the company to, among other things, file a project list and status report annually. Elkton agreed to replace 4.68 miles of Adela A pipe through 2025 at a rate of 1.56 miles per year. This is Elkton Gas's second reconciliation, although it is the first reconciliation covering a 12-month period. The company's 2023 proposed surcharge is based on 3.66 miles of main, 102 services and replacement or upgrade of piping and facilities associated with aging Adelaide A pipes. As stated in its STRIDE plan, the company's justification for main replacement of these pipes is a reduction in potential leaks, enhanced safety, reliability of the pipeline system, and a reduction in greenhouse gas emissions. Certain vintages of Adela A pipe have been known to be subject to brittleness and cracking, which leads to leaks. Since all current uncapped surcharges are above the cap, the current surcharges prior to reconciliation were set at the cap. In the instant reconciliation filing, the company overcollected. The company states the overcollection was due to operational savings that differ from the original project estimates, which were done by Elkton's previous owner. The reconciliation also reflects interest owed on the overcollection, and as a result, Elkton's STRIDE surcharges will decrease despite the overcollection. Staff recommends that the Commission direct the company to revise its tariff and bill the STRIDE surcharge revisions proposed by staff with an effective date of May 3rd, 2023, an effective date to which Elkton has agreed. Mr. Yole, Mr. Riley, and Mr. Thomas are available to answer any questions you may have.
Thank you, Ms. Garofalo. Counsel for Elkton Gas. Good morning.
Good morning, Mr. Chairman, Commissioners. Brian Quinn with the Venable Firm on behalf of Elkton Gas. We agree with staff's buck sheet, subject to those corrections, and here to answer any questions you might have.
Thank you, Mr. Quinn. Do my colleagues have questions? Seeing none, I would move that we direct the company to revise its tariff and the STRIDE surcharge revisions proposed by staff in its comments dated April 26, 2023, as revised today. Those comments can be found in table number 4 and 5. This would be with an effective date of May 3rd, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, Mr. Chairman. The next item on today's agenda would be from Verizon Maryland, LLC, its revised tariff pages regarding its local exchange service tariff.
Thank you. Good morning, Mr. Manka.
Good morning, Mr. Chairman and Commissioners. Alden Manka on behalf of staff. On March 31st, 2023, Verizon Maryland LLC filed revised tariff pages proposing to increase its residential local calling service, flat rate, and measured rate services by $1 in the local exchange tariff. These services are classified as Basket 1 Residential Basic under Verizon's alternative form of regulation, approved in 2010 by Commission Order 83137, Case 9133. The proposed rate increases are within the rate cap limits as defined in this alternate form of regulation for Basket 1 services, and the rate increase is smaller than the $2 or 20% limit on individual rate increases. Additionally, it has been over a year since the last increase for these rates. Therefore, staff recommends the Commission accept the tariff for filing with an effective date of May 3rd, 2023. I am available for questions.
Thank you. Nice job, and thank you for the buck sheet. Counsel for Verizon. Good morning.
Good morning, Mr. Chairman, Commissioners. I'm Doug Smith, Vice President, State Government Affairs for Verizon. Staff's memoranda and comments today are accurate and detailed, and we support their recommendations. The one thing I wanted to do is just spend a second to amplify on the cost drivers that bring us here today to raise rates by $1. In particular, we haven't raised these rates since 2013, or 2010 rather, and then we did it once in 2020. So over a very long period, we've only raised rates once. But But the cost drivers here over that long period of time, things like our technician collective bargaining agreements, they've got a cost of living salary increase, fuel, as you can imagine, inventory, poles, electronics have really gotten expensive. Copper and fiber materials have gotten very expensive. All of these costs have been putting pressure on our margins, and we've been reluctant to raise our rates. We know the impact it has on the consumer. But with those additional costs, particularly through this pandemic as all the costs went up, and the shrinking of our customer base. So we're losing landline customers to wireless service. So we've got a smaller base to spread those costs across. Those are the reasons that we've come here today to raise our rates. So Verizon respectfully requests that we have your approval of the filing that is before you today. Available for any questions you might have.
Thank you. Do my colleagues have questions? Okay. No. Commissioner Bubar.
Thank you. Actually, I just wanted to recognize Mr. Manka. I think this might be your first time in front of the commission.
For the administrative agenda, yes.
Yes, thank you. You did a nice job. Welcome. And thank you for the explanation. I was thinking that as like, I really don't know anybody who has a landline anymore. So it was quite interesting. So thank you for your explanation of the reason for the increase.
I would move that we accept the tariff revisions for filing with an effective date of May 3rd, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, Mr. Chairman. The next item on the administrative agenda is a request from Intelligen Resources LP. It has a bond cancellation along with a suspension of the electricity supplier license.
Do we have a counsel or representative from Intelligent Resources LP here today? We do not. Good morning, Mr. Schlicht.
Good morning, Mr. Chairman and Commissioners. Andrew Schlicht on the behalf of staff. On October 13th, 2010, Intelligent Resources LP was registered by the Department of Assessments and Taxation. On December 22nd of the same year, the Commission authorized Intelligen to broker electricity. 6 years later, on December 23rd, 2016, SDAT took the action of changing the status of Intelligen from good standing to forfeited. This change meant that Intelligen was no longer in compliance with one or more of the applicable state laws. In this case, SDAT cited that Intelligen had not filed the appropriate annual report and business personal property return documents. Nearly 6 years later, on September 7th, 2022, staff became aware of the continued operations of Intelligen despite its forfeited status with SDAT. Staff notified the company of such an issue, requesting it take the appropriate steps to remedy the violation. In working on this item, staff provided Intelligen with SDAT documents and contact information. Further, staff requested in letters sent to Intelligen that either the company return to good standing or provide evidence that Intelligen has been making an effort to address the situation. As of the present date, Intelligen remains listed as forfeit on SDAT's website. Staff recommends the Commission suspend Intelligen's license until the company returns to good standing with SDAT and issue a civil penalty in the amount of $6,500. Staff calculated the civil penalty by using a formula that relies on several factors, including, but not limited to, Intelligen's 2021 revenue and the duration of time in which it operated without a license. Staff is available for questions.
Thank you, Mr. Schlicht. Do we know where the company is today?
We do not. We invited them to the April 12th agenda, and we have since deferred it to today's agenda. As we understand, a filing was made by the company requesting another deferral, either to the May 24th agenda.
So this was scheduled for our April 12th docket, and we deferred it 3 weeks. Is that right?
That is correct.
Thank you. Good morning, Mr. Shu.
Good morning, Chairman, Commissioners. Ryan Shu on behalf of Office of People's Counsel. Just want to reiterate, our filing reiterates that we agree with staff's recommendation for $6,500 civil penalty and suspension of Intelligen's license until they are in good standing with SSTAT. I'm available for any questions.
Thank you to People's Counsel. Do my colleagues have questions? Commissioner Richard.
Just one question. In the buck sheet, it notes that the company was forfeit as of 2016, December 23, 2016, but we didn't really become aware of it here at the commission until September of last year. Is that just a lack of communication between SSTAT and here, or maybe you could help me understand how that period of time, that gap occurred? And is it possible we have other companies out there that we ought to check to make sure that they're good with SSTAT?
So this came to staff's attention when we received notice of a possible bond cancellation. So when we received notice of the possible bond cancellation from the surety company, staff went through a checklist, essentially, to check to see if the company was still in compliance with a number of components. And that was when we came across this matter.
Has there been any effort just to reach out to SSTAT to see if there are any other issues out there with again companies that are forfeit or delinquent with SSTAT?
Staff has not made such a request with SSTAT.
Okay.
Commissioner, unrelated to this one, but this is something that happens actually regularly, especially with our telecom companies, where they might become forfeited. And a number of times what the TGW department does is they will hold them up until such time as when they make an application with the commission until they get in compliance with SSTAT. But there is a process by which typically SSTAT informs the Office of Secretary once a year of companies' tax statuses with the state, and then our Office of Secretary goes through a process of trying to get them back into compliance. That typically happens at the end of the year and then runs through, I don't know, well, we'd have to work with the Office of Secretary to know what all their processes are, but there is a process by which SSTAT typically keeps us informed. It kind of broke down during COVID.
Right. Thank you for that. So I guess we learned of this instance because of the bond. So the company does still exist. They're out there because they did make the effort to get a new bond. Is that correct?
The company did renew the bond.
Okay.
The bond was renewed within the month, but that was how the matter came to our attention.
Okay, and staff have had a chance to actually speak to representatives of the company. It just seems odd that they're kind of silent at this point when we're having this proceeding today.
Staff has had the ability to speak with the company on several matters. When staff brought this to the attention of the company, it was first on the matter of the bond cancellation. When the bond was renewed, as staff was going through its checklist, staff noted that it was not in compliance with SSTAT and brought that to the attention of the company.
Okay, well, thank you. So they are answering calls or responding to emails, so we know that they are out there. Okay.
That is correct.
Okay, thanks.
Commissioner Bubar.
Thank you. I agree with staff's recommendation and thank you, Mr. Baker, for the explanation, because I had a similar question, wondering if there was a process that needed to be put in place at the staff level to look at SSTAT compliances or companies that are not in good standing and see if there's something we need to do instead of just waiting until we get a bond cancellation. But it sounds like maybe there's a time lag where we're trying to get those companies back into good standing. So thank you. That was a helpful dialogue. So I presume, I just want to check this assumption, there were customers being served in between 2016 and today by the company?
As staff understands, that is correct.
Okay. And I don't want to get into anything confidential, but do we have an idea of how many companies will be impacted with this company not having its license right now?
Staff is unaware.
Okay. All right. Thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I wanted to ask staff, does this company have to do an annual assessment filing?
An annual assessment filing with the commission?
Yes.
Yes.
So maybe staff could consider that a good point to proactively check the SDAT status of these and not wait. I mean, did I understand correctly? We waited 7 years to figure this out, or 6 or 7 years?
That is correct. Yes.
So, to Commissioner Bubar's point and others, Commissioner Richard, process upgrades. I don't know what the pros and cons of each possible solution are, but maybe some checkpoint in the process, and maybe it's because you're going to touch them all during the annual assessment filing. Do you have a comment on that?
Thank you for the clarification. Staff is open to reviewing its procedures to include the checking of SDAT and to make sure that the companies are in compliance with SDAT. Staff is open to such options.
All right, thank you. I hope staff will give that good consideration. Thank you, Mr. Chairman.
Thank you, Commissioner Linton.
Thank you, Mr. Chairman. Good morning to everyone. I had a question for staff regarding the calculation of the formula that you used to determine the fine amount. You noted one of the variables that you've noted here is, you labeled it S, meaning misleading statement. Is that supposed to incorporate the company's requirement to notify the commission if there's been any change in the way it's operating, or if there's any changes in its licensing status or status with the state government?
That misleading statement factor was included with regards to a statement made by the company back in October, in which I will not attempt to quote the company, but they stated along the lines that they had resolved the issue. That was back in October, and the issue remains unresolved. Staff took that as a misleading statement and is seeking to increase the civil penalty as a result.
All right, so suppliers also have a responsibility to alert the commission if there's been a change in their company structure or business, and a number of other elements. Is that requirement also incorporated into your formula?
No, it is not.
Okay. So then there's a possibility then that the fine could be even larger than what the staff has recommended. It's not a trick question. It means bigger numbers.
Yeah.
I turn to counsel.
So the penalty could be higher. I think based on our review of the company's revenue and their operations in the state, we felt like the $6,500 number was adequate for the circumstances. I think that given that the company has not provided the statement regarding their change in operations, and this has been ongoing for the past 6 years, that this information wasn't provided to us, that there would be the opportunity to increase the penalty. But I think at the moment, based on the stature of the company, that this penalty is sufficient for now. But if the commission believes that this penalty should be increased, staff would have no issue with that.
Okay. All right, thanks. I appreciate that. I just so my colleagues understand my line of thought here, my concern was that we were putting a number on the company's inability or lack of attention to providing updates to the commission in a timely manner. And the staff has noted here today that component was not included in their analysis here. So I'm comfortable with the fine amount. That's fine, as long as we know we're not pre-establishing what a fine number would be if a company's not responsive to the commission or not providing updates in a timely manner. Thank you. That's all I had.
Thank you, Commissioner. It should be clear that this is a minimum floor. The penalty could be much higher based on what was just discussed. Let me also say that the company's not here, not available to answer questions of the commission, so there's effectively a default judgment here. I move that we suspend the company's license to operate as an electricity supplier in the state of Maryland until the company provides evidence that it has returned to good standing with SDAT. That the company pay a civil penalty in the amount of $6,500 within 5 business days. And the company notify the commission within 30 days of any changes to the information upon which the commission relied upon in making its ruling. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, Mr. Chairman. The next 2 items on the administrative agenda are from Salt House Energy Advisors. Their applications to supply electricity services and natural gas services as brokers in Maryland.
Counsel for Salt House, please approach. Mr. Shu, is People's Counsel on this case or no?
No.
Okay. Thank you. Mr. Schlicht.
Good morning. On January 21st, 2015, the Commission authorized Salt House Energy Advisors LLC to broker electricity and natural gas. Salt House obtained a single bond for both its electricity and gas brokering. On October 21st, 2020, staff received a notice of cancellation from the surety company stating that if the bond is not renewed by Salt House, the surety company will cancel said bond. Staff attempted to contact Salt House, but received no response. The following year, on March 3rd, 2021, the Commission canceled both of Salt House's licenses due to the failure of Salt House to renew its bond. On October 20th, 2022, staff received another notice of cancellation from the same surety company for the same bond. Through discussions with Salt House and after reviewing Commission records, staff learned that Salt House was operating with a valid bond, but without an active license. To understand how this came to be, staff notes the unresponsiveness of Salt House in 2020 regarding its possible bond cancellation. Even though the bond itself was renewed, it is because staff never received notice of the bond being renewed that the licenses were canceled. Staff recommends the Commission approve Salt House's applications for natural gas and electric supplier licenses, limited to broker services. Staff further recommends the Commission issue a civil penalty in the amount of $1,200 for each license. Staff calculated the civil penalty by using a formula that relies on several factors, including, but not limited to, Salt House's 2021 revenue and the duration of time in which Salt House operated without a license. Staff is available to answer questions.
Thank you. If the representative from Salt House Energy Advisors LLC, if you could enter an appearance by providing your name.
My name is Herbert Wilkins, Jr.
Mr. Wilkins, how would you like to respond?
Staff's comments are accurate. The reason that we hadn't had communication with them was because our bookkeeper had neglected to update our address. So the information that the commission was sending, we were not receiving.
And what is your address?
Our address now is 1100 Wacomico Street, Suite 330, Baltimore, Maryland 21230.
You're in the Waco-Mico building.
Yes, sir.
Do you have an office on Boston Street?
We used to.
Would it surprise you if on your current website you say contact us, we would love to hear from you. Our address is 2400 Boston Street, Suite 102. That must be above the Outback Steakhouse, is that right?
No, it was across the street in a facility that was a mailbox. So this is a small business, sir. We have 2 clients in Maryland, I believe, and I think our total revenue for last year was roughly $36,000.
You're saying you had a mailbox across the street from Outback Steakhouse?
Yes, there was a package delivery space over there, and that was our mailing address. They have since closed. We used, so we have an outsourced CFO.
Hold on. I'm not done with my questions.
Okay, sorry.
I'm familiar with 2400 Boston Street. Your office here is Suite 102, but you're testifying today that it's really not a suite. It's a mail
It was
forwarding.
in that suite. So it's called Versity. So it's next to the nail salon, and in between the nail salon and DAP was a business called Versity.
Why on your website are you directing customers to contact you at the Boston Street address?
That has not been updated, sir.
That's a
And-
problem.
Yes.
That's
it
a
is.
problem.
It is. But again, sir, like I said, we have 2 customers in Maryland. This is a small business. Our customers are people that, so I work for a venture capital firm. This is one of our portfolio companies. The customers that we have are people that either myself or one of my 2 partners at the firm know. So we don't advertise publicly. We don't solicit customers publicly. All of our clients are people that either are portfolio companies of the venture firm or people we know. So the website is just kind of there for us to have a web presence.
Yeah, it's a very sad web presence. The site is currently under construction. To be notified when we go live, please click below. You recognize that this is public facing, correct?
Yes, sir.
When was the last time you received mail at the 2400 Boston Street re-forwarding services address?
That was probably 2 years ago, 3 years ago.
Who's the webmaster?
I'm not sure, sir.
Yeah,
I would have to check.
I'm not surprised.
I would have to check, sir.
You agree with the penalty?
I would like to see it reduced in light of our, like I said, we have 2 customers in Maryland and total revenue of $36,000.
On what basis would we reduce the penalty? It's $1,200. You just heard it in the previous item. They faced a $6,000 penalty.
Just the fact that we only have 2 customers in Maryland, and we weren't actively soliciting customers during that time period. It was just contracts that were in place already. So we didn't really conduct any business during that time period, and frankly, we haven't conducted any business since. So
You're not an out-of-state company, though. You're a Maryland-based company.
yes, sir.
Tell me about your presence at the Myco building.
We have an office there that's for the venture firm, and we use the same address for Salt House.
So if I were to go to that building on the directory, Salt House is not listed.
No, I believe it says SCI Management. Our mail comes there, but it says SCI Management on the thing on the wall.
And is SCI the VC firm?
Yes, sir.
What do you think an appropriate penalty would be for these transgressions?
I don't particularly know how staff calculates those, but
Oh, they explained,
Yeah.
correct? Yeah.
Yes.
They provided the methodology. It's very public. Questions from my colleagues? Commissioner O'Donnell.
Thank you, Mr. Chairman. I believe my question is for staff counsel initially. Would a violation of this nature, such as operating one of these companies without a license, be a Comar violation that would come on a every day as a new day of violation kind of basis? In other words, we have some of our Comars that say every day out of compliance is 10,000, considered potentially up to $10,000 a day. Is this one of those penalties?
Kenneth Albert on behalf of staff. I'll have to check that, Commissioner, but my understanding is you are correct that in the public utilities article, it talks about, it sets a maximum penalty on a per day basis. So one can look at a company that's operating without authorization as coming within that. So each day would be, as you say, a separate violation.
This company had a lot of days in there operating without a license. I guess my concern becomes, we have a kind of a formulaic penalty calculation, but considering our push for getting some compliance in the state, that may be inadequate at this point. In other words, you got this company saying $1,200 is too much, which almost made me fall out of my chair because they're in violation of effectively state law, GOMAR, and the penalty, whatever it could be much higher than that.
I would note that I'm sorry, Commissioner.
And I'm not sure that companies are getting the message that they sign an affidavit saying they're going to comply with all our laws and regulations, and yet, well, we heard from the chairman this morning on opening remarks, and in many other areas, we seem to see companies not paying attention to their obligation, and maybe we got to get their attention somehow. So how long has it been since staff has considered that formulation penalty provision?
My understanding is this may be the first or one of the first times we staff publicly presented this formula. Until now, it has been somewhat opaque exactly how the recommendations came about. Typically, we would cite the last few cases, but you went back there and you would be left unclear. So I think there's a significant improvement here in that we do have staff coming forth with, or putting forward to support the recommendation, an objective formula. And as far as you're concerned about the duration of the violation, that is the per day aspect of penalties, one thing I really like about this formula is it kind of takes that into account by going after the revenue. It's a sort of a disgorge. One could view it as a sort of a proxy for what the profits might be, by saying, yeah, you have to give up 5%. The penalty includes a 5% of revenue component.
Well, I think you're missing my central point, the essence of my point, which is the penalty may be inadequate for wherever it comes from. However it's calculated, it may be inadequate. And I'm suggesting that considering the fact that we're getting a lot of non-compliance issues, especially in the third-party supplier and broker market, that I don't think this is an improvement. I don't see it that way. I see this as, here we go again. Now, in the past, many of these were chalked up to, well, this is what we gave the last time. And I even saw some of that in this book sheet when I read it. It's consistent with other penalties, civil penalties we've given. But I'm suggesting to staff that maybe that's inadequate. Whether it's formulaic, whether the formula is new or old, I don't really care. What I do care is that these companies get the message. They have an obligation to comply with Maryland law and regulations as an obligation to the citizens of this state who issued them a license vis-a-vis the Maryland Public Service Commission. I don't know if you're hearing me or you understand what I'm saying. It sounds like you're pushing back saying this is okay, this is good enough.
No, I didn't mean to do that, Commissioner. I think the staff can certainly take this back and reconsider exactly how this formula is the components of the formula, or more to the point, the penalty that's generated by this formula. We certainly can take that back. We share your concerns about unauthorized operations and ensuring that the penalty is sufficiently high that it sends a real clear message to actors that there are severe consequences. And that's certainly something staff can take back and relook at this formula, which again is somewhat novel for us. We're comfortable with the factors, but we really appreciate your point that the resulting number has to be high enough to make it a real deterrent to unauthorized operations.
That's exactly right. If you don't have enough of a deterrent factor, it's not going to do any good. We'll collect the money and it'll go on doing business. Let me ask the company, sir, do you understand that your company could have been, and still could be, because we haven't taken final action yet, sanctioned at a much, much higher level than $1,200
Yes,
per
sir.
license? And yet you maintain it should be lower?
Well, I was just thinking with respect to the amount of revenue that the company has and the number of customers that we have in the state of Maryland.
Why don't you explain the company's vision with regard to compliance with Maryland state law and regulation?
So for us, it would just be to, one, update all of our address, which was an oversight on our part, which we apologize for. And as far as everything else, we've been in compliance. The issue with the bond was an issue that the Hartford had, and they corrected it. So otherwise, we've been in compliance, sir.
Well, see, that concerns me that you say that, because you're shifting blame. Well, our address was bad.
I'm sorry,
Therefore,
sir.
we were in compliance, except someone mailed it to the wrong address. That's your responsibility.
Absolutely,
ours.
sir. I was not trying to shift blame on that. I was saying that was an oversight on our part, which we apologize for. We take full
Right, so
responsibility for that.
Otherwise, you weren't in compliance. You were operating without a license.
Yes, sir.
That's the essence. For whatever reason. I don't care if the dog ate your homework or grandma put in your wrong lunch bag. You need to be in compliance.
Yes, sir.
Thank you, Mr. Chair.
Mr. Wilkins, do you recognize that your company was out of compliance for somewhere approximately 600 days?
Yes, sir.
Your penalty exposure is in the ballpark of about $6 million. Does SCI have the wherewithal to pay a $6 million fine today?
No, sir.
Do you have the wherewithal to pay a $1,200 fine today?
Yes, sir.
As
And it would be Salt House, sir, not SCI. Sorry.
As Commissioner O'Donnell noted, there is up to $10,000 per day per violation. This company has been effectively driving without a license, operating in this state. It's disappointing. When is your website going to be updated?
Probably by the end of the month, sir.
Why is it going to
We
take?
can have it, because again, we use a web developer and we're not a large customer, so I can try to get it done as quickly as possible, sir.
Yeah, the better answer would have been by the end of today.
Okay, sir.
I'll check tomorrow. If I see Boston Street on your website tomorrow, you'll be back here in a week or two.
Okay, sir.
Salt House is lucky that staff has the grace to make a recommendation to grant your company relicensure after 600 days of operating without a license. And the penalty is light. It's beyond light. I would move that we grant the company, Salt House Energy Advisors, LLC, a license with respect to item number 1 to operate as an electricity supplier in Maryland and as a natural gas supplier in Maryland with respect to item number 2, limited to broker services for the customer classes and service territories applied for and recommended by staff, subject to the company paying a civil penalty in the amount of $1,200 for its electricity license and $1,200 for its natural gas license, totaling a fine of $2,400 to be paid within 5 business days. The Commission further directs the company to file notice with the Commission within 30 days of any changes to the information in its application. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, sir.
Thank you.
Thank you, Mr. Chairman. The next two items on the administrative agenda are both from Management Services Partners LLC, DBA PowerSetter.com. Both are applications for licenses to supply electricity services as a broker and natural gas or natural gas broker services in Maryland.
Do we have counsel or representative for PowerSetter.com present? Mr. Jang, good morning. Where is the company?
Good morning, Chairman, Commissioners. Michael Jang on behalf of staff. As always, staff does recommend the company to attend the meetings. In this scenario, the company indicated to staff that they were not able to attend, but were supportive and does not oppose the penalty that staff recommended in its buck sheet.
I wish you had a nickel for every time you verbatim made that statement. Thank you, Mr. Jang. You may proceed.
Once again, good morning, Chairman, Commissioners. Michael Jang on behalf of staff. Items number 10 and 11 are applications from Management Services Partners LLC, doing business as PowerSetter.com, for an electricity broker and natural gas broker license, respectively. The company has applied to serve all customer classes and service territories for its electricity broker license, and all customer classes and service territories other than residential and commercial customers in Washington Gas Light Service Territory for its natural gas broker's license. The company will only provide broker services and submit a bond to fulfill its financial integrity requirement. The company currently provides broker services in 11 states, which can be found in staff's buck sheets. No complaints were found within the last 3 years for 6 of the states. 4 of the states did not respond to staff's query, and the 11th state does not regulate brokers. The company does its marketing through its website or other digital mediums. Staff reviewed some of the marketing materials and did not find any obvious concerns with those. The company did operate in the state of Maryland without a license during the time period of July 2021 to August 2022. Due to this violation, staff recommends that the company pay a civil penalty in the total amount of $3,000. Staff utilizes a variety of factors when determining the amount of a civil penalty, such as how long the company operated without a license, the revenues the company has earned during its unauthorized operation, potential outstanding assessments, and some additional factors. Like I indicated before, the company has indicated to staff through email that they do not oppose the penalty staff has proposed. Staff recommends that the Commission grant the company a license to operate both as an electricity supplier and natural gas supplier in Maryland, limited to broker services for the service territories applied for and recommended by staff. Additionally, staff recommends that the company provide training materials specific to its Maryland operations to Commission staff 30 days prior to utilization of the materials in Maryland. Staff also recommends that the Commission issue a civil penalty to the company in a total amount of $3,000 for its operation in Maryland as an electricity and natural gas broker without a license. Finally, staff recommends that the Commission direct the company to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license. Thank you, and staff is available for questions.
Thank you, Mr. Jang. Mr. Shu.
Thank you, Mr. Chairman, Commissioners. Just to clarify, OPC did not file anything on the last one because it didn't have any residential impact. On this one, again, we filed a letter agreeing with staff's recommendations, and I'm available for any questions.
Thank you. Mr. Shu, I'm curious, the office's position on the penalty methodology, relatively novel.
Mm-hmm.
You've heard some commissioners today express that perhaps on the lighter side of the range. Thoughts?
I think it's something that we could look at. I'm not offhand familiar with exactly what the margins are for such supplier companies, so I don't know if 5% is low or high. I think it's something certainly that could be looked at, yeah.
Thank you. The Federal Energy Regulatory Commission has penalty guidelines, somewhat similar, more complicated, but similar to the ones that staff counsel is using. Looks at number of factors from size, revenue, number of employees, infraction, severity of infraction, duration of infractions, repeat offenders, et cetera, et cetera. It's a little dusty and old now, but maybe something for the office and for staff council to take a look at it at some point. Do my colleagues have questions? Commissioner Bubar.
Thank you. It is disappointing the company's not here, but so in the staff buck sheet it says that the company has significant experience in the energy industry. So if they have significant experience, how was it that they didn't understand that they needed a license?
So staff did ask a request regarding this, and I can read out the response. This is what the company provided. In many states where the company conducts business, such as New York and Connecticut, a broker's license is not necessarily required for displaying suppliers' product offerings to prospective retail electric and natural gas customers on an online marketplace, particularly where the customer will be directed to enroll directly with the supplier. PowerSetter misunderstood that an online marketplace qualified as an activity in Maryland that would require a broker license. Soon after launching its site with offers for customers in Maryland, the company consulted with counsel, and out of abundance of caution, the company immediately shut down the Maryland-specific shopping page, and then they would not resume any other online sale activity in Maryland.
Okay. Thank you for that. So they stopped providing services, I think, in August of 2022, and then they submitted the license applications in January of 2023. Was there dialogue ongoing between the staff and the company during that time period?
I am unaware of any conversations between staff and the company during that time.
Okay. I was just wondering, it was like 5 months before they submitted again. So, okay, thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I would have asked the company a question, but since seeing that they're not here, I'll just echo my previous comments, your comments, and say that I'm not willing to make decisions here today, but at some point, if you want to send a message to these companies to stay in compliance with Maryland laws and regs, you got to send them a real message of deterrence. I think it requires a little bit more contemplation and deliberative thought, and I'll do that. I would ask all the parties to do that, but I just don't think that the compliance is necessarily being taken seriously in all quarters. Thank you, Mr. Chairman.
Thank you, Commissioner O'Donnell. I agree with your sentiments. Without the party here to respond, and with only the letter provided to Mr. Jang, I will move that we grant the company a license with respect to item number 10, top rate as an electricity supplier, and with respect to item number 11 as a natural gas supplier in the state of Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. That we further direct the company to provide marketing materials specific to its Maryland operations to the Commission staff and Office of People's Counsel 30 days prior to utilization of the materials in Maryland, and order the company to pay a civil penalty in the amount of $3,000 for its operation in Maryland as an electric broker without a license, and a civil penalty in the amount of $3,000 for its operation in Maryland as a natural gas broker without a license. That total amount, $6,000, is due within 5 business days of today. Finally, I move that we direct the company to file notice with the Commission within 30 days of any changes to the information in its respective applications. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, Mr. Chairman. The next item on the administrative agenda is from Maryland Water Service, Inc. It's 2022 unaccounted for water surcharge reconciliation for both Pinto and Highland Estates customers.
Good morning, Ms. Shea.
Good
Good morning, Mr. Chairman and Commissioners. Lucy Shea on behalf of staff, together with Barbara Weber of the Engineering Division. Maryland Water Service, Inc., MWS, filed its 2022 unaccounted for water, or UFW, surcharge reconciliation for both Pinto and Highland Estates customers, addressing Pinto Water Systems over-collection and Highland Estates water system under collection of water costs in 2022. Pinto's adjusted UFW percentage was equivalent to 4%, and Highland Estates was equivalent to 28%. The adjusted UFW percentage is the remaining UFW percentage after Maryland Water Service makes adjustments within the UFW calculation for certain sources of UFW, such as estimates of water loss from pipe breaks and leaks that have been repaired, estimates of operational use of water by Maryland Water Service, and estimates of fire department use of water for fire protection purposes. Maryland Water Service proposes to issue a $23.93 one-time credit to each Pinto customer for its over-recovery of water costs in 2022, and to implement a 12-month surcharge of $3.97 per 1,000 gallons to Highland Estates customers for its under-recovery of water costs in 2022. Pursuant to the stipulation and settlement agreement in case 9212, the company has not met its commitment to keep the annual adjusted UFW percentages in both of its water systems at or below 20%. In the stipulation and settlement agreement, the parties agreed that for any future year in which gross UFW amounts exceed 20%, they will not automatically recover. Staff concludes that although the company did not meet its goal of keeping the annual adjusted UFW percentage at or below 20% in the Highland Estates water system, the company made reasonable attempts to locate and mitigate leaks in 2022, and pursuant to the stipulation and settlement agreement in case number 9212, the company followed its prescribed procedures to reconcile estimated UFW losses. Staff recommends that the Commission accept Maryland Water Services filing and tariff revisions to issue a one-time credit of $23.93 to each Pinto customer and to implement a 12-month volumetric charge of $3.97 per 1,000 gallons for each Highland Estates customer. Staff continues to recommend that Maryland Water Service submit a report to the Commission containing detailed information on actions taken by Maryland Water Service to identify, quantify, and reduce levels of Highland Estates UFW and on the subsequent results achieved by those corrective actions. Thank you, and Barbara Weber of the Engineering Division and I are available to answer any questions. Thank you.
Thank you, Ms. Shea. Thank you, Ms. Weber, Office of People's Counsel.
Thank you. Good morning, Chairman and Commissioners. Nikki Wiggins on behalf of Office of People's Counsel. OPC supports staff's recommendation to approve MWS's surcharge request for Highland Estates. That's in light of staff's findings about the infrastructure for Highland Estates and the company's efforts to mitigate UFW. We do express our concern that the UFW percent is at 28% when the company commits to 20% or below, and that's particularly in light of the fact that Highland Estates customers are in the midst of a multi-step, pretty significant base rate increase at the moment. So any additional surcharge is a little bit of a financial hardship. We also support staff's recommendation that MWS continue to file quarterly reports about their efforts to mitigate UFW so that the Commission and parties can make sure that their current efforts are effective in reducing UFW. I'm here to answer any questions. Thank you.
Thank you, Counsel, for the utility.
Thank you, Mr. Chairman, Commissioners. David Buglemans on behalf of Maryland Water Service, Inc. Also have with me today Mr. Dana Hill, the president of the company. We appreciate staff and OPC's comments on this matter. I would like to provide a brief update on the company's efforts, especially with respect to Highland Estates. As we indicated in our filing in 2022, the The company performed 68 acoustic leak detection evaluations on the Highland Estates system and located and repaired 4 leaks found on that system. When this did not return desired results, the company engaged an independent third-party engineering firm to conduct further evaluations. And I'm happy to report, as a result of these efforts, the company discovered and repaired leaks representing about 648,000 gallons per month at Pinto and 43,800 gallons per month at Highland Estates. These repairs will be reflected in the company's upcoming report for Q1 2023, and we expect them to reduce UFW levels further, including bringing Highland Estates hopefully below the 20% threshold. Again, this report will be filed with the Commission, be available to staff and OPC, and to the extent the parties would like to discuss, we'd be happy to engage in further discussions with OPC and staff. We hope this additional context is useful. Again, we have Mr. Dana Hill here to answer any questions. Appreciate your consideration this morning.
Thank you. Mr. Bugelmans, these aren't large water systems, Highland Estates and Pinto, is that correct?
That's correct. They're very small, especially Highland Estates.
How many customers?
Do you have the customer count? It's very small. Highland Estates, I think, is in the range of 20 customers. So it's, the issue, especially with Highland Estates, and again, this isn't to minimize the importance of these matters, but a very small leak with Highland Estates can drive the UFW level, these percentages very high. And so it is a continuous, I don't want to say struggle, but, the company has to make, substantial efforts to keep these numbers low for that system.
Ms. Wiggins knew the answer, which is impressive, more than the utility being able to cite that number on the fly. So a question for Ms. Wiggins. You stated in your testimony, your recital just now, as well as in your filing, your letter, that there's this increased financial burden. Of course, anytime a utility rate goes up by a penny, there's more of a financial burden on the customer. But were you implying that these ratepayers would be disproportionate? I'm trying to think. Highland Estates sounds like a very fancy neighborhood with McMansions. I don't know if that's the case. Perhaps these are low-income customers. Perhaps they are high-income customers. But when you make the assessment that there is an increased financial burden, I'm led to believe that the customers can't afford the rate increase. Is that true? Have you spoken with any of these 40-some-odd customers?
No, excuse me. No, sir. I don't think that was what I meant to imply. My apologies. I don't think the implication is that they can't afford it. It is a increase of $1.60 over the last surcharge that was in place. So back of the envelope math, based on average usage from the last rate case, we're looking at maybe $60 increase for the year. So I don't think it's anything that's unmanageable, but it certainly is something to take into consideration, because they're in the midst of rate increases for base rates, and there's going to be one more rate increase coming up. And so to the extent that we can manage these surcharges, I think that we should focus on, or the company should focus on doing that.
I agree with you. It's not an insignificant rate hike. I was just more curious as to whether the office had direct contact with any of the customers, and the answer is no.
No, sir.
Okay. Thank you, Ms. Wiggins. Do my colleagues have questions? Commissioner Bubar.
Thank you. I just have a question on roles and responsibilities. So is Maryland Water Service responsible for detection and fixing of leaks, and the city of Cumberland is responsible for the water quality?
Yeah. So the Commissioner, the way it works for both of these systems is they purchase the actual water supply from a municipal source. But the company delivers. So the company really is a distribution company, and then they purchase from a third-party source. But as a distribution utility, the company is responsible for detecting and repairing leaks on the delivery system.
So the leaks that you were talking about being detected and fixed, and the update you provided, are those paid for under current rates, or is that expected to be part of something that would be in future rates?
It's just an aspect of the company's operations. this is a accounting mechanism to deal with uncollected costs associated with the company purchasing water from the municipal sources that it has to purchase from. So this doesn't take into account the cost of the company of repairing the leaks. This is just dealing with the supply cost basically for the water.
Okay. I think that's all I have. Thank you.
Thank you. I would move that we authorize Maryland Water Services Incorporated to issue a one-time credit of $23.93 to each Pinto customer and to implement a 12-month volumetric charge of $3.97 per 1,000 gallons of water for each Highland Estates customer by accepting the company's proposed Pinto and Highland Estates tariff revisions effective May 1st, 2023. And direct the company to submit a report to the Commission containing detailed information on actions taken by the company to identify, quantify, and reduce the levels of the Highland Estates unaccounted for water, and on the subsequent results achieved by those corrective actions. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you.
Thank you, Mr. Chairman. The next item on today's administrative agenda is from Columbia Gas of Maryland, its annual STRIDE reconciliation factor and revised IRIS rates.
I imagine this is the same team for 13 and 14. Is that right, Mr. Greger?
That is correct,
Okay.
Mr. Chairman. And actually, with the Commission's indulgence, I would like to read or present item 14 first. That would make more sense,
Please.
Given the timeline. Thank you, Mr. Chairman. So good morning, Mr. Chairman, Commissioners. James Greger on behalf of staff. I'm joined by Dr. Pamela Coates of the TGW Division and Mr. Carlos Acosta of the Engineering Division. This item concerns a filing made on January 5th by Columbia Gas providing its 2023 supplemental STRIDE project list and associated surcharges. By letter order dated December 7th, 2022, the Commission approved the 2023 project list submitted by Columbia and accepted the surcharges proposed by the company. The Commission further directed Columbia to provide an update regarding how the company would accomplish its commitment to replace 8 miles of priority pipe in the coming year, as is required by its STRIDE settlement in case number 9479. In this filing, Columbia proposes to replace an additional 3.6 miles of priority pipe by executing 11 projects, 2 projects in Hagerstown and 9 projects in Cumberland. From the list of proposed projects, only 1 project will be completed under STRIDE, and the additional 10 projects will be worked outside of STRIDE. The project to be executed under STRIDE is the Prospect Street work, which has an estimated cost of $650,000. It should be noted that the original STRIDE project list approved by the Commission on December 7th had an estimated cost of approximately $17.4 million. The company is proposing to add the Prospect Street project to be considered under the estimated approved budget of approximately $18 million in compliance with order number 88852, issued on August 28th, 2018, in the case number 9479 docket. The 2023 STRIDE project list approved on December 7th reflected an IRIS revenue requirement of approximately $1.83 million. With the addition of the STRIDE project in the supplemental project list, the revenue requirement increases to approximately $1.85 million. However, the increase in revenue requirement does not change the monthly IRIS surcharge because the surcharge were already at the rate caps. Staff recommends that the Commission note the filing of Columbia Gas of Maryland, Inc.'s 2023 supplemental project list. Thank you, and we're available for questions.
Thank you, Mr. Greger and team. Good morning, Council for Columbia.
Good morning, Mr. Chairman, Commissioners. Ted Gallagher on behalf of the company, Columbia Gas of Maryland. And obviously, we agree with the observations and recommendations in staff's buck sheet, and we're available for questions.
Thank you. Thank you, Mr. Gallagher. Do my colleagues have questions? Seeing none. Mr. Greger, do we wish to move to number 13?
Chairman, Commissioner O'Donnell just came off mute.
Oh, I'm sorry. I missed the hand. Commissioner O'Donnell.
Sorry, Mr. Chairman, I couldn't get my hand up in time. Never mind, Mr. Chairman. I'm going to forego my question. Thank you.
All right. You'll have another opportunity. Mr. Gregor, do we wish to move to 13 now?
Actually, Mr. Chairman, these items can be taken separately as far as the staff's recommendation, but if you want to just give one.
I'll take a vote.
Yes.
Okay, I'll take a vote on item number 14. I move that we note the filing. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, Mr. Chairman. Once again, James Gregor, appearing on behalf of Commission staff with Carlos Acosta of Engineering Division, Lucy Shea of Accounting Investigations Division, and Dr. Pamela Coates of TGW Division. This item is Columbia Gas of Maryland STRIDE reconciliation filing for calendar year 2022. Staff's comments detail the review by the Engineering Division of the work performed by the company's gas distribution system under the 2022 STRIDE program. Section 4-210 of the Public Utilities article provides for the recovery of reasonable and prudent investment associated with accelerated gas company infrastructure improvements and replacements through a surcharge. Under PUA Section 4-210D3, the surcharge may include property taxes, depreciation, and the gas company's authorized pre-tax rate of return and the cost of a STRIDE project. Surcharges are capped under PUA Section 4-210D4 with a rate for residential customers capped at $2. For non-residential customer classes, the cap must be consistent with the proportion of total distribution revenues that each class bears in accordance with the most recent base rate proceeding for the affected gas company. The Commission reviews each STRIDE company's collections annually after actual costs have been booked for the preceding year. This reconciliation covers the fourth year of Columbia's second STRIDE plan. The company reports that it closed all 9 projects planned for 2022, as shown in Table 1 of staff's comments. A total of 15.2 miles of pipe was estimated to be installed, and an actual total of 14.79 miles of pipe was actually installed. The calendar year 2022 reconciliation indicates an IRS surcharge over collection of approximately $92,072. As a result of this over collection, the revised residential rate is calculated to be $1.77, a 23 cents under the $2 residential IRS surcharge cap. Correspondingly, all other customer classes will receive a reduction to the respective surcharges. Table 9 on staff's comments capture all proposed monthly STRIDE surcharges by customer class. Staff recommends that the Commission accept for filing the company's proposed tariff revisions effective May 1st, 2022. Mr. Acosta, Ms. Shea, and Dr. Coates are available to answer any questions you may have on this matter. Thank you, Mr. Chairman.
Thank you. Thank your team as well. Mr. Gallagher.
Again, thank you, Mr. Chairman, Commissioners, and Columbia again agrees with the observations and recommendations in staff's buck sheet and standing ready to answer any questions.
Thank you, Mr. Gallagher. You're not fighting back last time, like last time.
Nothing to fight back on.
Good. Commissioner O'Donnell.
Thank you, Mr. Chairman. Now I got all my thoughts together. It's more of almost a rhetorical question, but it's a question we know the answer to, but I want to get it on the record. None of these surcharge filings or project lists or any of the STRIDE filings related to these 2 items constitute any type of prudency review or pre-approval. And I would like the parties, Mr. Gallagher and staff and OPC, if they wish, to concur with that.
I guess we will go first, Commissioner. Yes, staff agrees with that statement.
And Columbia also agrees with that statement.
Commissioner O'Donnell, if you could repeat the statement, I'd appreciate it.
Yeah, my question is, none of these 2 filings, surcharge, project list adjustments, anything associated here constitutes a pre-approval or a prudency review.
Agreed, Your Honor.
Can you please make an appearance?
Thank you. Juliana Bell for OPC.
Thank you, Ms. Bell.
Mr. Chairman.
I think those were the right answers, Commissioner O'Donnell. Any additional questions? Seeing none, I would move that we accept the tariff revisions for filing with an effective date of May 1, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Thank you, Mr. Chairman. The final item on today's administrative agenda is from Chevy Chase Village et al. Request for scheduling conference regarding Potomac Electric Power Company streetlight pole agreement.
At this time, I would ask all the parties to get a seat at the witness table to the extent there are seats available. One for PEPCO, one for council for Chevy Chase, staff, and OPC.
You all have any issues with the revised?
Yes,
Okay, oh well, there we go.
we just haven't had a chance to look at them, and I thought we had agreed to those.
Well, one of the things was that I didn't realize somebody put mass plant in. That was inside. So that's an issue. And
You guys don't have a-
the other
are you guys in
part
this case?
is just to be a
Okay.
little bit more descriptive in terms of.
All right, final item of the day. We received correspondence from Council for the Municipalities and PEPCO on the 7th of April. This is a scheduling conference. Ms. Ferguson, I'll start with you. Well, let me first reflect on the fact that the Commission appreciates the parties have been working conscientiously together for so long on these issues. Based on the confidential filing made by PEPCO on April 7th, it appears that the parties have made significant headway, and it looks like maybe there's about a half dozen unresolved issues. Is that right, Ms. Ferguson?
I think that's a fair description, Mr. Chair.
Thank you. If I could ask the folks in the back row to take your conversation outside. Thank you. This room has wonderful acoustics. I could hear every word in the back. So the purpose of today is to hold a scheduling conference. The parties appear to agree that there are no material issues of fact in contention. There are policy issues that are unresolved, and it seems like we have a statement of issues, approximately 5 or 6 statements outstanding. The parties seek an opportunity for oral argument and possibly briefing before the commission. So let me solicit the input of Ms. Ferguson and Mr. Michael, and if staff wishes to provide their input as well, we'll walk out of this hearing room with a schedule. That's the goal.
If I may, yesterday, we have been communicating consistently about this whole process. And in fact, as of yesterday, and I apologize to PEPCO, I noted a mistake, or what I see as a mistake, in one of the descriptions of the issues, and wanted to correct that. In addition, I wanted to explain a little further what our issue about Verizon as being part of or being involved in these proceedings is. I sent that to PEPCO yesterday, and Mr. McKeel informs me that they have not had an opportunity to respond to that appropriately through their system. But I do have an update which I can send in as to how we see the issues. They are all the still general category of issue, but as to how they're described, I think there needs be a little more fine-tuning on that.
This is with respect to the joint user Verizon and pole attachments process. Is that?
That's one of them,
That's
yes.
one of
To more fully describe that, if the commission doesn't feel that needs any further description except in the briefs, then I'm fine with that. But I did want to make one correction to one of the issues that was presented, which was how to value streetlights and abandoned poles, and I neglected to see that it was described in the paragraph 1 as being the mass plant calculation for a specific municipality, and that actually wasn't one of the alternatives. The alternative the municipalities had requested was a calculation based on that specific jurisdiction, not mass plant, because mass plant is something that's PEPCO's position all along. And if I'm misunderstanding their accounting procedures, that's possible, but our argument has been it should be the depreciated value of what's on the poles.
Okay, well, we don't need to get into the specifics today. Obviously, some information transpired overnight. Allow Mr. Michael an opportunity to respond. It would be ideal if the statement of issues can be consensus and filed. So we have, it looks like 6 issues unresolved that we will hear argument on and render a decision in the weeks or months to come. Do you see any problem, Ms. Ferguson, in reaching a consensus joint statement? I thought this was, but apparently there's a few issues that need to be ironed out.
And as I've said, my apologies to both Commission and to PEPCO for that. It's something I saw yesterday upon looking at this another time. We have been working on many different versions of what you are seeing. So but I do apologize for that.
The next logical question is, how long would you need before you can file a joint statement of issues?
We haven't had a chance among us to talk about that, but I would assume sometime next week. We'll give a look at the updated information that the municipal corporations have given us. But it's my understanding that when we filed on the 7th, they had looked at the issue list. You know, it was a joint issue list, but we'll give it the consideration as Ms. Ferguson said. We got it yesterday, and I haven't had a chance to speak with my folks on that. But we have been working consistently, and there is more good news. We did have a section, Romanet 2, ongoing negotiated issues, and we have been working collaboratively with the municipal corporations and Ms. Ferguson, and we have resolved a large number of those, and we would be making a filing with those resolved issues also. So we have continued to narrow the issues and work to get as much agreement as possible.
Excellent. Do the parties have a joint proposal to provide to the commission today? Timeline?
Well, unfortunately, no, but I will say this. We had recommended 3 weeks for initial brief, 2 weeks for a reply brief, May 24 and June 7th. Ms. Ferguson and her clients want June 2nd and June 19th. I can do either one, but we had the 3 and 2 weeks. And Ms. Ferguson, for her clients' reasons, want June 2nd and June 19th.
Do you oppose that?
We do not oppose that, Your Honor.
June 2 for initial briefs and June 19th for reply. Did I hear that right?
I believe those were the dates that she sent out in her email that I have written down.
June 19th is a state holiday, Chairman, so you might want to make it June 20th.
Thank you.
Juneteenth. Thank you.
And when would you envision oral argument being? If we receive the briefs on the 19th or 20th.
I'm available.
You're available.
You know, I mean, this is what I do.
Anytime after the 20th. Miss Ferguson?
I believe that for July, I am also available.
So a date
on
in
a particular day, but I'm in town.
Okay. Mr. Gregor, any input from Staff counsel.
Yes, Mr. Chairman. Staff also concurs with the June 2nd and June 20th brief and reply brief dates. July looks to be a little packed with other hearings, but I believe staff will also be available whenever the commission finds it convenient to schedule oral arguments.
Is there a good day in July, Mr. Gregor, that you would prefer?
I believe any time the second or third week of July, Mr. Chairman.
There will be an upcoming change in composition of the commission, so I won't be here. However, we can schedule it for second week of July. I don't know what the agenda is going to look like for the administrative meeting, so perhaps best not to tack it on to that. How would Thursday, July 13th work for the parties?
It's fine for me.
I would just say that we have our contracting attorneys in-house and our outside contracting attorney that deals with full attachment agreements that would be doing the argument. I need to check with them, but tentatively, I think I can agree with the 13th. I just need to take that back.
Yes. Take that back. Let the Secretary's office know if that is not a good date. Obviously, work with Mr. Gregor and Ms. Ferguson. Are there any other parties that we're missing? I don't think so. Ms. Ferguson, you used to have 6 people at the table, but you are speaking for all of them.
I am. They asked if they should be present, and I indicated that they did not need to be here today because we were scheduling.
Very good. Any other matters that we need to address?
The only question I had for Jim was, it sounds like there's a question if Verizon should be included. I don't know if they need to be included in any of this discussion.
Yes, Mr. Chairman, we've reached out to Verizon. They said that they were going to get a hold of their pole attachment experts. We haven't heard back yet. So Verizon has not been a part of this process so far. They probably will need to be looped in at a later time, but...
Mr. Verizon was just here, and we rarely see him, and he's gone. Okay. Let's loop in Verizon. So we have a number of contingencies. Before we actually nail down the July 13th date, somebody contact Verizon. Mr. Michael, you contact your expert counsel. And then we'll sort this out. But for the time being, initial briefs are due June 2nd. Reply briefs are due close of business June 20th. Do you need a page limit?
Boy, I hope not.
I would hope not too. I don't know, Miss Ferguson charges by the word or by the page. Miss Ferguson, any?
By the hour.
By the hour.
But I am try to be efficient.
Let's also set a date for a filing to receive the joint consensus statement of issues, and hopefully it is consensus. Of course, if you reach an impasse, flag it, and we'll address that. Today is May 3rd. Can you file that by May 15th?
Oh, yes.
Yeah, I'm
Yes.
nodding from both. Okay.
Yes,
so
sir.
May 15th, joint statement of issues to be filed. Anything else today from the 3 parties?
Nothing from staff, Mr. Chairman.
All right, we'll see everybody back sometime in July.
Thank you.
Thank you. This hearing is adjourned.